Hi everyone, welcome to the second video on Civil Procedure 1. As I promised you in my last video, today I will be addressing you on the topic failure in appearance or default in appearances, or simply as we all call it, ex parte trials. Now before I move into subject content, I would first like to address you a bit on the type of questions that appear on papers. As you can see, majority of the questions based on this lesson take a very practical approach, where sometimes you are required to analyze or to evaluate the correctness of an order given by a trial judge, and sometimes where you are required to set out the procedure to be followed in a given situation. Now, to do all that, it is important that you know your legal provisions, what they set out for, the elements contained in them, the conditions to be satisfied under these provisions, along with the relevant legal authorities, in your case, the case laws. So, firstly, I will be discussing on these legal provisions in detail, and towards the end of the video, I will give you a very brief guidance as to how you can structure your answer to a practical related question. Before we move on to discussing the legal provisions, it is important that you identify what a valid appearance is and what default is. Now, when it comes to a valid appearance, according to the cases of Fernando versus Fernando and Chettiar versus Chettiar, it was discussed there that where a registered attorney at law appears in a court on behalf of a party, that would constitute a valid appearance. And a default in appearance basically means that neither the registered attorney at law nor the party is present in court on the date fixed for trial. So having identified what constitutes a valid appearance and what is default, it is now important to identify this ex parte trial legal provisions in detail. So for your convenience in studying, I have structured the law relating to ex parte trials in 3 different sections. Firstly, we are going to discuss about default by a defendant. Secondly, we are going to talk about the procedure to be followed in setting aside or in vacating an ex parte order or a decree. And finally, we're going to talk about the default done by a plaintiff. Moving into the first section, which is default by a defendant. Section 84 and Section 85 sets out the legal provisions pertaining to the law on default done by a defendant. So as you know, generally, when a case starts, the plaintiff files the plaint in court, for which the court will issue summons on you if you are the defendant. And there, court will provide a fixed date for you to answer this plaint. Now, Section 84 identifies 3 main ways in which you can fail or in which you can default being a defendant. Firstly, it states where a defendant fails to file his answer on or before the date fixed for answering. Secondly, it states where a defendant fails to file his answer on or before the subsequent date fixed for answering. That is, for example, a scenario like you are given short notice and you don't have enough time to answer the plaint. So therefore, you plead to court, you ask court to grant you a further date, and then you fail to answer that plaint on the subsequent date. And the final instance is where you have filed your answer already, but you fail to appear in court on the date fixed for trial. Now, if the defendant party defaults in either of the 3 ways, the court will consider 2 conditions. Firstly, court will consider if the defendant was duly served with summons, or secondly, where the defendant was given due notice on the next date of trial. So if the court is satisfied on either of these conditions, where a defendant has defaulted in either of the ways that we discussed a little while earlier, then court will proceed to hear the case ex parte. That means when you say ex parte, it basically means your voice as the defendant will not be heard in court. You are not supposed to present your stance, your position in court. Only the plaintiff will get the chance of presenting his case. So now when we talk of these elements and the conditions and the legal provisions under Section 84, it is important for you to understand what constitutes duly served summons. This is where the case of Sirimavo Bandaranayaka versus Times of Ceylon becomes important. If I'm going to quote right exactly from the judgment, it states that all that needs to be proved is that summons reached the defendant and was left with a human agency. Now, when we talk of human agency, it's important for you to understand that you can't just leave it on a table. You can't just leave it lie about. You can't just slip it under the door assuming the defendant will collect it. It needs to be served to the defendant himself. Now, another aspect of the concept of duly served was identified in the case of Dharmasena versus People's Bank. Here it was held that a defendant should be given a fair opportunity to present his case. Let's take into example a situation where you are given short notice of summons and you don't have enough time to answer your plaint, or you don't have enough time even to grant a proxy to your attorney at law. In such a circumstance, duly service of summons is not done. The due service is not complied to. So therefore, the defendant is placed in a very unfair position. Therefore, that will not constitute the due service of summons. Now, having discussed the legal provisions under Section 84, it's important to bear in mind about Section 60. I will repeat it, Section 60 of the Civil Procedure Code. Here it states that an order for an ex parte trial is not possible where defendant fails to appear after being served with summons by registered post. Now let's take into consideration a situation where you are the defendant and you are being served with summons by registered post. But having done that, you fail to appear. What would be the appropriate conduct of the court in such a circumstance? According to Section 60 of the Civil Procedure Code, the court should order a fiscal or the Grama Niladhari of that particular or the relevant division to personally serve summons on you. Having done so only, they will expect the proper appearance in court by a defendant. Now, Section 85, subsection 3 becomes important in a situation where you are present as one defendant and there may be other defendant parties who are defaulting in appearance. What would happen to you in such a circumstance? According to Section 85, subsection 3, it states that the plaintiff can move court for judgment against the defaulting parties only. I repeat, the defaulting parties only. So in your case, if you are present in court for that particular trial on that particular day, then your evidence will be heard. Your submissions will be heard. It will take the face of a normal trial, whereas the defaulting parties will be liable for an ex parte trial. Now with that, we come to the end of the first arm of ex parte trials, which is default by defendant. Legal provisions, Section 84 and Section 85 come into play there. Now we move on to the second arm. That is the procedure to be followed in setting aside or vacating. Setting aside is also known as vacating an ex parte order or a decree. Now the legal provisions pertaining to the procedure is set out in Section 86 of the Civil Procedure Code. Here it's important to remember that Section 86, subsection 1 was repealed by Act number 53 of 1980. I will repeat the amending act, which is number 53 of 1980. So thereby leaving Section 86, subsection 2. Accordingly, if a defaulting party, so in this case it's a defendant, excuses his default and requests court to set aside the ex parte order or the decree, there is a manner in which the defaulting defendant has to do it. So this manner is set out in section 86 subsection 2, which is the application for such setting aside should be done within 14 days of the service of decree by way of a petition supported by an affidavit with notice to the plaintiff, that is your opposing party, and finally, most importantly, showing reasonable grounds for your default. Now, when I say reasonable, it's important to remember negligence is not a reasonable ground. As decided by the case of Honorable Attorney General versus Hera, negligence will not amount to a reasonable ground. So here, if the court is satisfied that your grounds are reasonable and if you have done the application within 14 days, if you have followed the necessary procedure to do so, then court will set aside such ex parte order and allow you to proceed the case from the defaulting stage. But if by any chance your reasons that you've set out in the petition are not reasonable, let's say you set out a reason as to you had a function on that particular day, that is why you didn't appear in court. That is not going to be very reasonable if you hadn't even attempted to inform court by way of another lawyer at least. So in such circumstances, court will dismiss your application and will hear the case ex parte. Now that is the situation, or that is the procedure to be followed when setting aside or vacating an ex parte order. Now this Amending Act number 53 of 1980 brought in a new section, or brought in a new amendment, which is section 86 subsection 2A. It spells out to say that prior to entering into a judgment against a defaulting party, which is the defendant in this case, the court may set aside order for ex parte trial only if the plaintiff consents, and then the defendant can proceed from the defaulting stage. Now this provision was given legal recognition in the case of Vijay Sekara versus Vijay Sekara. Now, having discussed the procedure to be followed in such a situation, it is important for us to look at a few cases with regard to giving notice to a plaintiff, and also as to what constitutes the 14 days within which you can apply to court. Firstly, when you are giving notice to a plaintiff, it's always important to remember that it is for the interest of justice. It is in the interest of justice. And here what happens is, when you are leading evidence as a defendant to show that the plaintiff failed in serving summons to you, then the plaintiff, if he has actually done so, he has a fair opportunity of leading evidence or rebutting your evidence to show that it was duly served. That is for the administration of justice. So this was given legal recognition in the case of Vimalavati versus Thottamunne. The case is Vimalavati versus Thottamunne. Now secondly, looking at what constitutes 14 days within which you need to make the application, the case of Ceylon Brewery Limited versus Maradana Wine Stores. Ceylon Brewery Limited versus Maradana Wine Stores becomes important because here firstly it was held that the period of 14 days is mandatory, and secondly, the 14 days would include public holidays, Saturdays and Sundays. That is how your 14 days will be calculated. Now, taking a look at such case law, it is also important to understand if you as the defendant, having done such an application, if the plaintiff or the opposing party does not have a opportunity to object to such an application. Yes, you can as the plaintiff. That is, when the defendant is making an application under section 86 subsection 2, you will be given notice by courts. Then what you should do as the plaintiff is you must file your objections in court. Then once you file your objections in court as to why the application should be dismissed, court will hold an inquiry to listen to both the parties. So if the court is satisfied, or if the court feels that the defendant's grounds are reasonable, then automatically the ex parte order will be set aside and the defaulting defendant party will be allowed to proceed from there. But if the court feels that the plaintiff has set out reasonable grounds as to why the application should be dismissed, then automatically the case will be heard ex parte. The application under 86 subsection 2 will be dismissed. Now with that we come to the end of the second arm, which is the procedure. Now the third limb we need to look at in ex parte trials is default done by a plaintiff. So section 87 of the Civil Procedure Code looks into the legal recognition of default by plaintiffs. According to subsection 1, where a plaintiff and a defendant, that is both the parties, or the plaintiff alone defaults in appearance, the court will dismiss the plaintiff's action. Secondly, according to subsection 2 of 87, a dismissal which was done under subsection 1 means that a plaintiff cannot bring a fresh suit on the same cause of action against the defendant. That is very straightforward. Now you will wonder if a plaintiff defaulting in appearance will not have a remedy like the defendant did. Well, yes, you do, and that is provided for under section 87 subsection 3. Here it states that the defaulting plaintiff needs to make an application to court within a reasonable time with notice to the defendant, pleading court to set aside the dismissal by way of a petition supported by an affidavit and setting out the grounds, the reasonable grounds for default. Now when we talk of reasonable time period, it's important to remember you can't keep court waiting for you. You can't keep the defendant waiting for you forever until you make the application. Your time period within which you make the application needs to be very reasonable. That is a maximum of maybe 1 or 2 weeks. And here again, court will consider your application as court did in the defendant's case. If the grounds that you have set out in your petition are reasonable, are truly reasonable as to why you defaulted, then what the court will do is, court will set aside the dismissal and will allow your application and you can proceed in your case. Now with that we come to the end of the arms we've discussed under ex parte trials. Taking a look at what we've discussed so far, firstly we identified what a valid appearance is, what a default is, the 3 arms. Firstly, the default by a defendant, which was covered under section 84 and 85 of the Civil Procedure Code. Secondly, the procedure in setting aside or vacating an ex parte order, which was set out in section 86 of the Civil Procedure Code. And finally, default by a plaintiff, which was set for in section 87. Now, next we are going to look at how we can analyze or evaluate the correctness of an order. That is the very practical scenario that I spoke to you at the beginning of the video, how you can structure an answer. So here I'm going to give you a very brief guideline of 7 steps that you can follow in structuring your answer to such a question if you get one in any case. Firstly, you need to identify the defaulting party, that is if it is the plaintiff or the defendant that defaulted in appearance. Secondly, according to the identified party, that is the defaulting party, you need to identify the relevant legal provisions. If it is the defendant, section 84 and 85. If it is the plaintiff, section 87. In third, you need to analyze these legal provisions very carefully in detail. For that, you need to have a good understanding about the legal provisions. In fourth, while analyzing you need to identify the elements and the conditions which you need to fulfill. And in fifth, You need to place the case facts, that is the case facts that you are provided at the examination. You need to place those case facts in line with the identified elements or the conditions which need to be required. Next, you need to support your stance by using the relevant case laws. That is, if you are taking a position, you need to support it with the most relevant case laws. You need to explain your case laws. You need to connect the case laws to the present facts. And finally, you need to argue your question, your answer. That is, you need to connect your answer and the question. If you are supposed to argue or analyze or evaluate the correctness of an order, you need to say that this is correct and this is the reason as to why it is correct, or this order is wrong and this is the reason as to why it is wrong. So with that, we have come to the end of this lesson, failure in appearances or default in appearances, or simply as we call it, ex parte trials.